Hello, everybody. Welcome. Thanks for joining us today. My name is Mike Gibb. I run AccountsRecovery.net, and I want to welcome you to today's webinar on how you're likely to screw up the model validation notice. The model validation notice included in Regulation F, or the debt collection rule from the Consumer Financial Protection Bureau, can reduce the chance of being sued by a consumer for what is contained in a collection letter. But making sure that the letter you send is what is required if you choose to use the model validation notice is not as simple as filling in a few blanks. Today in this webinar, which is being sponsored by TCN, a panel of compliance experts from across the ARM industry are here to identify the different areas of the model validation notice that are likely to cause problems for companies in the ARM industry and how those problems can be avoided. Before introducing the panel, I want to take a quick second and talk about an event coming up tomorrow here at AccountsRecovery.net, and that's called Q&ARM. This is part two of a three-part series where we have three companies who are going before a panel of industry experts to answer questions about their products and services. Think of it as Shark Tank meets the ARM industry. While there are no prizes or investments, the information that comes from this discussion should provide great insights into the tools and resources that are shaping the ARM industry for the next generation. I'm just going to put a link in the chat box here for anyone who wants to click on it and sign up for the event tomorrow. We're a company, so we got Belto, TCN, and Simplicity Collection Software presenting, and our panelists are going to be Judd Peak, Chris Taylor, and Rick Rainhill. So sign up for that if you haven't already. Now, let me tell you a little bit about today's speakers. John Bedard is a nationally recognized authority on the Fair Debt Collection Practices Act and the Fair Credit Reporting Act. He serves as counsel to several professional trade associations, including the Georgia Collectors Association. John is a former member of the board of directors of the industry's leading professional trade organization, ACA International. He serves as the state of Georgia compliance chairperson for ACA International and is a former chairperson and program designation award recipient of ACA International's members attorney program. Stephanie Jackman is the leader of Ballard Spahr's debt collection team and a partner located in Ballard's Atlanta office. Stephanie is nationally recognized for her expertise in collections compliance and litigation across all segments of the financial services industry, including traditional financial products, fintech and online lending, healthcare, and student lending. Porter Heath Morgan is general counsel for Morgan Financial Group and a partner with Malone Frost Martin. Heath specializes in providing general counsel and compliance services for third-party collection agencies. He is a third-generation collection attorney and has worked in the commercial, medical, and retail AR industry for more than 20 years. He is a member of ACA International's Members Attorney Program and a founding member of the Colorado Creditor Rights Bar Association, where he serves as a member of the board of directors. Brent Yarborough is a principal with Maurice Witcher. He primarily focuses his practice on regulatory compliance in the defense of consumer law claims. Brent has experience representing financial institutions, debt buyers, collection agencies, and law firms. He has defended numerous class actions and individual claims involving the FDCPA, the FCRA, the TCPA, the Truth in Lending Act, and various state law claims asserted against lenders and their assignees. The format for today's webinar is going to be a panel discussion. We encourage everybody to submit questions, and we'll get to them as we proceed through our conversation today. To submit a question, please enter it into the Q&A tab or send it to us through the chat module on your Zoom webinar control panel. This event is being recorded, and recording will be made available in the coming days on AccountsRecovery.net. Finally, since we're going to be talking a little bit about compliance today, let me read the following disclaimer. This presentation is not intended to be legal advice and may not be used as legal advice. Legal advice must be tailored to the specific circumstances of each case. Every effort has been made to ensure this information is up to date. It is not intended to be a full and exhaustive explanation of the law in any area. It should never be used to replace the advice of your own legal counsel. All right, with that, we can start our discussion today. So what we're going to do is go through some of the different parts of the validation letter, the model validation notice, and talk about some of the areas that people need to be aware of when it comes to that specific part. And what we're going to start talking about first is the itemization date. Heath, you were the first one to log in today, so we're going to let you go first. Maybe you can start talking about some of the issues that people may have when it comes to using the itemization date in the model validation notice.
Sure, thanks, Mike. And I think before we jump into itemization date, let me just preface this conversation with, we're talking about how you're likely to screw up the model validation notice. what does that actually mean, screw up? Because for me, what I'm seeing right now and talking to agencies is kind of expectation setting. And the expectation that if you follow this model validation letter to a T or close enough, you aren't going to get sued. Well, unfortunately, I'm happy. I'm not happy to tell you that you are going to get sued for using either the validation letter or for a substantially similar notice of that. And so what I think we want to look for and set expectations about is, what kind of risk are you going to take? Because what I would say is, let's look at New York and the model that New York used with their letters when they made the change back in 2015. And we saw thousands of lawsuits come in based on meticulous claims, based on requirements of the letter, because there was no a real safe harbor. And a lot of those lawsuits are still being flushed out in the courts. The good news is that, you'll get sued, but someone else is going to get sued first. So you'll be able to likely stay your lawsuit and wait for these issues to flush out through the courts. So I guess what I would say initially is, let's look at your expectations. How much do you want to vary away from that form validation notice to see what kind of risk you're willing to take? With that, I certainly, there's a big issue of itemization date. And one thing I would say, I work with a lot of healthcare agencies, and they're struggling with this issue a lot because they're not getting this information from the client. And this takes a lot of discussions with your clients. And let's be honest, on the healthcare side of things, a lot of times healthcare clients aren't exactly responsive when their agencies come to them with an idea of including more information. And if that's the case, if you have clients like that, then I think one issue you need to look at is even going a step higher. And we need to, as an association, we need to engage with the HFMA associations, the hospital associations, the physicians group associations, to be able to educate them about what they need to provide their agencies in order for their agencies to comply and not screw up this notice. So that's kind of what I would initially say on the itemization date. But because between now and November 30th, you're going to have a lot of agencies wrestling with what date to go with and move forward with for this itemization date.
All right, thank you, Heath. Appreciate that. Anyone else want to weigh in on some issues they see with the itemization date or some ideas about how to deal with it?
So we've got a question I already saw in the
We do
from David Wordshaw, and I think to try to address that, I'm not sure this is going to address this question specifically, but the rules require, and the commentary is pretty explicit about the fact that you have to be consistent with using an itemization date. So if you choose one, whether that's the charge-off date or the last payment date, you've got to stay consistent with that throughout. Now, he might be asking the question, if you use, say, the charge-off date for itemization, can you still refer to the last payment date if your client is asking you to do that, even though that's not your itemization date? And I have to say, I have not given that any thought. I think it's a good question. What do you guys think?
I was looking at that as well from David, and I was wondering, tell me if I'm wrong, this could be crazy. I was wondering, I know you have to be consistent with what you're using, but I'm wondering if an agency, if that is only as to that particular client's accounts. So if you had a completely different client, and I don't know what's underlying the question, but say you had Bank of America and Chase, just to pick two banks, and Bank of America is fine with charge-off date, but Chase wants you to use date of last payment. I think you might be able to vary as long as you're consistent for all of the accounts that you're handling for that particular client. And you'd say to the bureau or the regulator or the court, this is how this client has directed me to do it, and I use it consistently on all of their accounts. And there shouldn't be any confusion, because anybody that's being collected on a Chase account would have this date versus Bank of America would have a different date. So I don't know if that's helpful, or if people think I'm taking on too much risk to quote Heath. I completely agree with him that a lot of these are, what is your risk tolerance and what makes sense within your own organization? But that was my initial reaction, is could you perhaps vary the date you're using by client. You have to be consistent within the client, but across clients, it could be different.
Yeah, Stephanie, and I agree with you. There needs to be consistency. I'll have to go look at it again. I thought they meant consistency by account, and that it was permissible to use a different itemization date, even for the same client.
I actually think you're right.
Account. I think
Yeah.
you got to be consistent by account, because the same consumer can't get two different answers about what the itemization date is. I'll have to look at that again, just to be certain. But what I've been telling clients, that the most risk they have with respect to itemization date is that they are not now developing and working with their own software provider to add fields into their system that they don't currently have. They need all 5 of the itemization date potential fields in their system. Not only do they need all 5 of those, they need 5 additional balance fields, because the requirement is that you identify the balance of the debt on the itemization date. So not only do you have to have current balance, you have to have balance on the itemization date as well, which means at least 10 more fields in your system, so that you can properly even begin to attempt to comply with these new obligations to provide the itemization date and the itemization of the debt. And so what I see as some of the biggest risks is not properly building their system and coding accounts in a way that identifies, this is the itemization date for last payment. This is the itemization date for charge off. This is the itemization date for transaction date. You have to have all those fields and balances associated with them. And your system needs to be capable of using a consistent balance and date by account, depending on how you're going to collect it. And getting that information in that format from your client is not something that happens overnight. That's going to take some time. Just like Heath said earlier, we got to be communicating with our clients now. We need to be educating clients on the kind of information we're going to need from them, to the extent we're not getting it from them now. You know, you began this discussion, Mike, with the question about itemization date, but I don't lose sight of the obligation to also provide itemization of the account from the itemization date forward. And so that means interest, fees, payments, and credits. Also, you got to have those. And to the extent your system is not capable now of separating interest, fees, payments, and credits, well, now we got more IT work to do. And so with respect to the itemization date and itemization of the debt, I think that's where a lot of risk lies if we don't get our systems programmed correctly to accommodate all the different permutations of how we might disclose that information to consumers.
Well, and I think, John, you hit the nail on the head, because David was kind enough to give a little bit more insight. And you said we need to be educating our clients. That's exactly where my head went when I was reading the follow-up that was provided on this particular question. Clients have to understand, and I recognize they may not understand. I was thinking about those that continue to insist on 1099-Cs being in their collection letters and the agencies getting sued. And I realize you don't always get indemnity from these clients, and I won't name the company that I knew was doing it. You have to educate your clients, and that's where I would start, Dave, because I agree with you. I think that if you are putting a different date as the itemization date, but have a client who is still asking you to put the last payment date in the letter as well, you are absolutely going to get sued. That number one doesn't conform to the model form, because the model form most definitely envisions, I'm not saying you can't defend it, but for the safe harbor protection, the model form envisions a date, and it's a date that's used consistently throughout, as John pointed out, the account. I'm thinking as a best practice, maybe you treat it the same for the whole client, and it might be operationally easier. But John, I actually think your recollection is completely correct, that it's at the account level. So you don't have to do that. And so then I started thinking, okay, well, if the client insists, what would I do? And I would make the itemization date be whatever it is, itemization date, blah, label it, charge off, whatever the date is that you're using. And if the client's going to insist that you also have another date, like last payment, it goes into the body of the letter. It becomes more part of the text. It's not called out at the top. It's distanced. You're definitely going to have to be prepared to defend that it's substantially similar. And candidly, for whatever it's worth, I think that's going to be a hard argument to make right now, because it's a completely new and arguably in the Bureau's mind, duplicative data field, right? So you're going to have to explain in the body of the letter, and we don't like varying the language of model forms or the validation notice, what this is. So if you can convince your client and get them to understand why it is so significant that they pick one or the other, and if they won't, it's easy for me to say as outside counsel, request they indemnify you when you get sued, but you're probably not going to want to do that. I think the best you can do then is to try to have some physical and contextual separation and clarity, and hope that you can defend. I don't know if others see that differently.
Yeah, I think that might be a solution. My concern with it is I'm looking back at the rule, and it's not an optional disclosure. You know, the rule lists some optional disclosures such as a telephone contact, a reference code, certain very confined payment disclosures, and a different itemization date, or in this case, a last payment date, if that's not your itemization date, is not one of the listed optional disclosures. So I would be very concerned about including it. I agree with Stephanie. I would talk to the client and say, this under this new rule, we can't do it if we use charge off. And then the solution might be to use the last payment date as the itemization date instead.
And so I think maybe technically speaking, I'm not prepared to say that the rule would prohibit that, but I pretty firmly believe that you're going to lose your safe harbor protection by adding that information to a letter.
Right, and that's what I was getting at. Yeah, when you're talking about maintaining the safe harbor, you've got to stay within these constraints, and they've got optional disclosures you can include.
Yeah.
And this type of information, the last payment date is not one of the optional disclosures it's listed.
Yeah, Dave's got a follow-up question about some agencies that had a New York settlement.
No, he didn't want that.
What's that?
No, we'll move on for a second.
Okay.
Just to sort of break in, there's a question here I think actually I can answer. So I'm going to do that. And that is, this is the suggested model notice versus a mandated one. Yes, that is true. See, I can do that. And I'm not going to charge you nearly as much as anybody else.
However, there is mandated information that must be in the initial written communication that you send to the consumer. So don't confuse an optional model form with mandatory information that has to be in your initial written communication.
Got it.
And now the price of Mike's advice just tripled.
No, but John's exactly right. The model form is both including the required content, but importantly, a certain presentation and flow and visualization of it that is very important to the safe harbor protection the Bureau envisions, is my read of it.
Correct.
Right. It's hard to imagine deviating from the model form too much and still complying with the disclosure requirements. I mean, you have to be substantially similar if you want to get the safe harbor, but I'm not sure how far beyond substantially similar you can go before you're not in compliance with this section of the rule.
Yeah, Mike, we had to add on because we need our clients to understand why they pay our bills.
Right.
Completely understand.
And hey, a good way to deal with recalcitrant clients is to raise your fee, right? And so for all of those people on the phone whose client demands that they put more information in the letter, okay, well, maybe we just add a few basis points to the fee.
There you go. I'm going to jump in and just hit the pause button briefly on a conversation and say a few words about TCN, the sponsor of today's webinar. TCN provides cost-effective call center solutions for traditional contact centers, collection agencies, and thousands of businesses worldwide. TCN has continually stayed current with TCPA and CFPB changes by introducing enhancements to its core platform, one of which is TCN's natural language compliance, which uses smart algorithms to build compliance rules naturally. Simply type in your rule into the TCN Compliance Manager, and the natural language compliance engine will build an easy-to-understand compliance rule. One example of a rule could be deny outbound calls before 8 a.m. and after 9 p.m. You could even type in a rule that would limit 7 calls in 7 days. There's no limit to the number of rules TCN's processing engine can compute. TCN software is a platform suite that provides built-in data management services that eliminate data entry errors, business intelligence with reporting dashboards, call recording with storage, smart IVR with payment capabilities, speech analysis and transcription, and much more. Regardless of size, location, or application, TCN can provide robust solutions for your call center and collection agency. Please give TCN a call today or visit them at www.tcn.com for more information. Thanks again to TCN for sponsoring today's webinar. John, I want to circle back to something you were talking about before with respect to the itemization date, because you have a question that came in. If a consumer has an account, let's say one with Dr. Smith and another with Dr. Jones, would we need to use the same itemization date for that consumer with those two clients? Or can we use different itemization dates by client so the consumer may have two different itemization dates based on the different client?
The answer is yes. You can use a different itemization date. If you're going to try and collect those two accounts in the same validation notice, that becomes a little tricky. We're going to have to get on second pages. We might have to, do some gymnastics if we're not going to use a second page. But I don't think there's anything in the rule that prevents a debt collector from using one of the 5 optional itemization dates for client A and a different one of the 5 itemization dates for client B. How we disclose that to a consumer is where it gets tricky. And it gets even more tricky if what we're trying to do is disclose that to a consumer in a single validation notice. Not impossible. The Bureau talks about how to do that, but it's something that anybody contemplating that, call one of these 3 brilliant lawyers here on the phone to get that letter reviewed, because you're going to need to really be careful about that.
Yes, I think about, John, to your point, I completely agree with you. And it's sort of like the 7 and 7. I know we're not talking about call limits today, but the idea that even across multiple accounts, even with the same creditor, you get 7 attempts per account, unless you have to count them to something. But then if you end up connecting and talking about all 3, so the building blocks are already in place, that when you start combining things under the rule, disclosures, contact attempts, et cetera, and doing multiple counts within it for efficiency, it can get complicated. And I totally agree with you. I think, honestly, if somebody wants to try to disclose multiple accounts for different creditors in one validation letter using different dates for itemization, don't call me, call John, call one of these other guys. They're smarter, because my answer is going to be, you're crazy. Pay for the stamp.
Yeah, that's probably the best advice that you're going to see in a lot of these different circumstances of different accounts, different dates. It's going to be worth the cost to separate those out and send multiple letters. And even to John's point too, if you've got, and I've seen some questions, and we can dive into the attorney issue, because that's a whole nother issue. But I think a lot of the answers are going to be separate, 2 pages per letter, not even on the back of a letter, but actually 2 separate pages. And your postage costs will be going up in a lot of our answers to these hypotheticals that we're seeing, because the best way to keep it simple, if we're talking, again, going back to the risk, the more you want to complicate adding accounts and adding different dates, the more you're going to raise that risk, and the harder it's going to be to sit out of that litigation and wait for someone else to get sued first.
We were gonna talk about this later, but we've had some questions come in, and it kind of seems like it fits in with what we're talking about now. But we've got a bunch of people asking about multiple debts in a single validation notice. Would you recommend that? Not recommend that? How would you, or how would you advise your clients if they came to you with a question about how to handle multiple debts, whether or not to send it in a single validation notice or not? Brent, we'll let you kick us off.
Well, yeah, we're going down 2 or 3 levels from what Stephanie just outlined. I think it's the last round of a really nerdy FDCPA drinking game. And this is one of the things I was concerned about talking about is the multiple accounts. And then we start throwing around multiple accounts for different clients with different itemization dates, and I almost left. So yeah, I mean, there's the rules specifically provide that you can do this and describe options for how to do it in the itemization, and providing potential separate itemizations off the front page. So but yeah, that's my initial reaction. It's so much easier than what we're talking about, but this is actually doable, and the rule does provide for it. Yes.
still have to be careful about it. And don't forget this model notice. This model notice does not provide you safe harbor from any possible violation that could befall you, right? If your data is incorrect, the safe harbor it doesn't protect you. If you have the wrong itemization date, if you have the wrong balance, if you have the wrong interest, fees, payments, and credits, this just because you use the model form doesn't mean you have safe harbor for those things. It's safe harbor for a very narrow set of claims, which is your obligation to provide the G notice, as we all sort of know, and for overshadowing claims. But you still have to be very, very close attention to make sure that you are itemizing debt correctly. There are two things you have to do. You have to provide an itemization date, which is a date and time, and you have to then itemize the account from the itemization date to the current balance that you're trying to collect. And so, just like Brent said, there are provisions in the rule about how to do that properly over multiple debts. And the Bureau's solution to doing it over multiple debts is to either provide cumulative numbers and provide them where the information is located on the model form now, or if you don't want to provide cumulative numbers, maybe perhaps because those cumulative numbers are across different clients, then you can add page 2, not the back of the page, page 2 for an itemization.
A question that came in here, I'm just trying to find it. Here it is. Sending a validation notice collecting on an aggregate balance for a medical debt consisting of multiple dates of service with their own individual balances. Stephanie, that sounds like your scenario.
So going back to what Brent and John were saying, which I think illustrates, so yes, there are provisions in the rule that talk about how to deal with multiple accounts. Account is not the same as consumer. There are ways that there will be circumstances where it's easier, circumstances where it's more difficult. Certainly strikes me as easiest, I shouldn't say easy, but easiest, when you have multiple accounts placed by the same creditor using the same itemization date. And I feel like that's probably what the Bureau was envisioning when it sat there writing this. It wasn't spinning into all of these other scenarios. And they may have been raised in comments, I get that, but they say they read them all. They didn't have time, or the rule wouldn't be out yet. So they're keeping it simple. They see this as simple. They want this to be simple. We all know that's not true. We all know it's very complex. And then we factor in, if I have 3 clients that place an account that relates to the same consumer, it'd be much better to take advantage of the multiple debt provision, put it in one letter or send one email. I can think about the ways that you talk about not just cost savings to you, but the consumer gets it all in one place, one-stop shop to resolve. It's great. But then that's when these variances that, we're joking about, but they'll absolutely come in. You'll start thinking about your business partners will start thinking about, can we combine this together? Great. But what happens if Chase wants it date X for itemization and Bank of America wants a different date? So there's some variance. Can you defend it? Sure. It's different clients and you're staying, sure, on the plain face of the rule. Will a court get that and grant your motion to dismiss? Some will, some won't. So it's really just a question of, what are you willing to manage and how confident do you feel that you can manage it in keeping as little variance when you're disclosing multiple debts? So for the medical question, if these are all debts from the same facility, probably on the easier side. You're going to have whatever you've agreed with that facility would be the date for itemization purposes. It all relates to the same ultimate consumer. You put the accounts in, it's going to flow through and make sense. But if you have it from 3 different medical facilities, you start to have that variance. You may have a variance on what the itemization date they want is. It doesn't take much to confuse the least sophisticated consumer. So that, to me, I think it's a business decision about how much risk you're willing to take on and how you'll defend it. But the more you can keep it simple and kind of segmented at least by client, to me, that's going to be easier at the end of the day.
Yeah, if I understood the question, I think my response is, you should hope that Heath gets that meeting with the medical administrators that he was talking about at the beginning of this, because if we're talking, I think it's pretty common to have multiple accounts that arise from separate treatment dates. So you have one patient has an accident, goes to the facility multiple times and incurs separate accounts because they're by each time they set it up separately as a separate debt. So you're going to have different itemization dates, which I think is going to be very difficult to accumulate. But if they send one invoice out for all of those visits, then and then you have a final statement before it's sent to collections, that could be an itemization date that applies to all of them. But you're going to have to find out whether they do that. And that's what Heath and John were talking about at the beginning. I mean, it's not going to take until November 30th to format this letter. It is going to take until November 30th for some collectors to get on the same page with their clients and with their IT on how to make sure that everything that goes into the letter complies with the rule.
I think to Stephanie's point too, like if you're looking at it from a risk and who's pushing, what are the cost savings of combining multiple accounts on one letter? And if there is a cost savings, if it's significant, look at it this way, for the first year, from November 30th, 2021 to 2022, send them all separate. Let the case law flush itself out on multiple accounts. You'll have plenty of decisions come November 2022, and then you can make a decision on whether it's a good idea to start combining those accounts together. Don't be that guinea pig. Let someone else be the guinea pig and pay the litigation costs to defend that in court.
We have a question that came in about using a second page. Does that take away the safe harbor if you use a second page in your model validation notice?
You do not have safe harbor for page 2. If your page 1 is the same or substantially similar to the model form, you do not lose safe harbor because you've included a page 2, so long as you followed the Bureau's instructions on how to properly refer consumers from page 1 to page 2.
So John, let me ask you a question, because we've gotten some questions here on the attorney letters. So in light of that protection, what would you think is a safer strategy for attorney letters? Is it obviously you can't fit the attorney's signature, the attorney letterhead in one page with the model validation notice. Do you have that attorney letter be a second page to that model validation letter? Or is it a good idea to have the law firm send out the model validation notice with the disclaimer, no attorneys reviewed this account, and then 30 days later have the law firm sign their attorney letterhead, meaningful attorney review for that case? Do you have any thoughts on that?
So let me understand. So something prevents the attorney from sending out the model form? Am I understanding?
Well, just the space requirements on the first page, and the signature block. Most attorney letters that come out from law firms are signed by attorneys. The ones that we're seeing asked in the questions here. And my thought is, you can have that model validation letter to a T on one page, and then have a cover letter, if you will, essentially saying, your account has been signed to this law firm for collection. Please see the additional page for your rights, and have that signed and reviewed. Because in the alternative, I see, basically enough space to add just that, the language provided for the circuit that no meaningful attorney has reviewed this, and then waiting to a second letter to where you're not having that class action liability to have the attorney review and sign a law firm letter from there.
Right. Well, I suspect that all the attorneys in this space are meaningfully involved in the collection of their accounts. So they don't have a need very much to put that language in there. I know that's not answering your question, but that's my story and I'm sticking to it. They're all meaningfully involved, so they don't need to tell anybody that they're not. Now, I am always sensitive to what lawyers have to put on their letterhead, and what the bar rules say they have to disclose about where they're licensed and things like that. And so your point is very well taken about sort of space problems. I didn't see anything in Regulation F that says a debt collector or a lawyer or any debt collector for that matter is limited to an 8.5 by 11 sheet of paper. And I know everybody that just heard me say that stimulated their gag reflex at the thought of maybe using a larger size piece of paper. I don't, I'm not a fan of that. But if you're going to use paper, it's a potential solution to a space problem. I know that we can cram font size down only to a certain level because there are some states that have font size requirements. I really think, though, that, you know, the distant future of all this is going to be in the electronic world, and I'm not sure we have the same constraints in the electronic world when we're sending emails, text messages, things like that. I still haven't answered your question because I don't have a good answer for it yet. But I would really encourage a client to try and work with the constraints of a single page so that they can put it all in there so they're not running over on page 2, things that ought to have been on the model form. I do think perhaps if you do if your letter does run over onto a second page, I'm not sure what that does to the safe harbor, even though the form is all still the same. It just sort of drips over onto a second page. And so, you know, the Bureau seems to use language that is very clear. It talks about the reverse side of a page for certain things, and then it talks about a separate page for certain things. And I think that's deliberate, and you know, and a careful reading of that by everybody listening, I think, is worth paying attention to. So that was a very long answer, the one that didn't answer your question. Thank you.
Well,
Misdirection, John. Well done.
I'm going to try to answer part of it. I think so I'm thinking, you know, I think we're talking about the Greco disclosure, and you know, it makes me think that the part of this that I fear the most, or that I sort of see the most potential for immediate litigation, are the disclosures required by applicable law. And you can include disclosures required by applicable law on the reverse of the letter, or you can include disclosures required by applicable law if the law actually specifies the content. It can be used on the front of the letter. But what I don't know is this a disclosure that's required by applicable law? And I think, because, you know, certainly one response would be what John was saying is if you're meaningfully involved, then you don't have to include the Greco disclaimer. So you have a choice sort of as to whether you need to disclose it. And I think that's the kind of thing we're going to see litigation over, is what is a disclosure required by applicable law. And I thought we'd be talking about that in the context of time-barred debt disclosures, which I assume we will. But yeah, this is the litigation. I think this is what Heath was talking about. One of the things that Heath was probably referring to at the very beginning when he said you're going to get sued even if you do it right. I think this is one of the things you're going to get sued over, and we're just going to have to sort this stuff out in court and find out what can go on there, what can't.
Well, and I think it was John's point early on about, I think that we're talking about things that as we move into the more of the electronic, online, email, text, self-service portal, I'm thinking about a lawsuit I'm involved in. It just came to my desk yesterday, actually, and it involves an allegation that a letter that was sent without Greco language has violated the FDCPA. And so my hope and prayer was, when I called the client, I would find out that there's a reason they don't have the Greco language, because they feel they can defend the meaningful attorney involvement. And alas, they've already given me wonderful declaration and information that takes me through an online trackable, auditable system that allows an attorney to quickly document how they reviewed the account, verified the info before the letter went out. The more you can invest in things like that, you may not be there now, but I agree with you, John, that's where it's going. And it actually, maybe it's an investment right now that feels big, but it pays dividends on the back end, because I've got fodder. I wish it was a motion to dismiss, but you know, we're going to talk in advance, see if we can get it dismissed and they understand the process and go away. And if not, after we win summary judgment, I'll be seeking my fees because of the auditable, really well captured information they have that they sent me as a PDF. It shows time and date stamp, what they did, how they did it. It was great. Those kinds of systemic controls, I think, are just really helpful with the attorney issues that were in. Did this need to be reviewed? Did it not? Maybe we can just show it was. I don't know what other people think about that.
I think you could show it was, and that's part of the risk and the point is that, to John, you know, what John said earlier, I mean, all attorney letters now that go to collection law firms are pretty much reviewed under most CFPB consent decree standards. You know, the issue I was asking and differentiating between a signature block and The Greco is that I just don't see room to have that wet signature on there that's going to stop that lawsuit in the first place. Without that wet signature, then you're going to see the lawsuit that you saw, Stephanie, where they're going to sue you anyway and let it flush out. So again, it's looking at ways to avoid screwing up this and finding a way to put that wet signature on there that's going to keep that lawsuit away on the attorney side.
Before we move on, I have a question that was sent to me privately. I think so. The person stayed ultra anonymous, and that is, I can tell there are no collectors on this panel. I know we can't have multiple debts in the same letter. I would appreciate how we are supposed to do that. Us collectors are not sending 10 letters when we can otherwise send one letter when it is the same consumer getting treated by the same medical provider. That is not practical.
Amen. Yes, and I don't think you heard any of us say you can't do that. We were talking about risk. You can do that on a second page, and the way to do that is to do it the very same way you were supposed to have done it on the first page. And so it talks about itemization date, it talks about itemization, it talks about balance. And so there is a section of the model form on the left side at the top that talks about this is how much you owe, right? All of that information needs to be on the second page for every single account, and it needs to be clear that you're talking about each account. If you're talking about different creditors, the rule isn't very specific on how to identify which creditor your itemization applies to, but I submit that you need to include that so the consumer knows which creditor that itemization belongs to. But you can do that. And I do understand the need to send one letter instead of 10. I get it, especially when you're sending 1 million letters a month. I mean, you're saving hundreds of thousands of dollars by doing that. I get it. And there is a way to do it, and that's how you do it.
All right, let's move on. Sorry, go ahead, Brent. Go ahead.
Well, I was going to say, I think it would be a possibility. I'd like to get some confirmation if you agree with me, but I think it'd be a possibility if you have medical debts, like I was saying earlier, you could itemize them in the cumulative if you had one itemization date. So if you can get one itemization,
creditor.
Right, one credit, exactly. One, if it's one creditor, and I thought that's what the question was getting at. You have 10 accounts coming from the same creditor for the same consumer. How do we put those all in there? And I think if you've got the same itemization date, you could do it in cumulative fashion on the front page. But I think the challenge, particularly with the medical debt, is going to be to get the same itemization date. And one way you might be able to do that is to have your client send a statement out, accumulate, with all the debts in one statement, send that letter out, and then you can use that statement date as the itemization for everything.
Yep.
That's a great idea. Great suggestion, Brent.
And also, and I'll just point out one thing too, that statement doesn't qualify as a last payment, as a last statement if it was sent by an entity that is a debt collector and not a creditor. So if your hospital group uses a servicing partner that is a debt collector and they're sending the statements, there can be an argument that that doesn't qualify as a statement. So you're going to want to check that as well and see if the entity that sent the statement is a creditor and not just a collector.
Let's move on. We've got hours and hours of stuff to talk about and less than hours and hours of time left. So let's see here. What would be the best thing to talk about next? Let's talk about the validation notice date. There's a lot of things around. We've talked about the itemization date, but there's another date component to this that is just as important. And John, why don't you walk us through that?
So one of the other pieces of required information on your new validation notice, when those rules become effective in December, is the date in which the validation period expires, right? The date it expires. In the past, we used to tell consumers, unless you dispute this debt within 30 days of your receipt of this letter, well, the Bureau doesn't like this because the consumer has to do math. 30 days from what date? 30 days from the date on the letter, 30 days from when I receive it? Now the Bureau says, you just got to tell the consumer what that date is. If we hear from you by January 3rd that you dispute this debt, and then you go on with all these disclosures. And so being able, your system now, we talking about fields and system and IT, right? We have to be able to capture and identify the date on which the validation period expires, and that date has to be populated in your validation notice that you send the consumer. Now, the Bureau gives us some guidelines on some assumptions that we can make about when the consumer receives the notice for purposes of figuring out what the last day of the validation period is, because the rules do not change the statute, which is that, the 30 days begins when the consumer receives the notice. And the Bureau now is creating a rule on how to calculate that date so that we can give consumers the date instead of telling them what the statute says, which is figure it out 30 days from the date you get it. The Bureau it tells the debt collector that they can assume that the consumer has received it not later than 5 days after you've sent it, excluding weekends and holidays, right? Weekends and federal holidays. So potentially up to, let's see, a long weekend. It could be, 4 days, 5 days in between the time you send it and the time you can assume, actually 8 days, 5 plus potentially 3 for a long
Be
weekend.
9, Thanksgiving weekend.
Is a longer weekend, right? Is the Friday a holiday too?
I just, as soon as I said that, I started to think, I don't know if that Friday is a federal holiday, but
Yeah,
may not
it
be.
is in Brent's world. Brent takes that day off every year anyway, and so when he's
I'm
sending
still
letters,
eating.
he includes that.
That's
as a
right.
vacation day. And so, so there we have. So now we have to program our systems to calculate that date based upon the rule that the Bureau has given us: 5 plus weekends and holidays, and that's going to be the date we use now. That we tell the consumer that they need to exercise their rights by that date. That's sort of the ending of the validation period is what we need to disclose the consumer using a date, not using a formula.
So is it just as simple as putting 38 days out, or is there more to it than that? Like, what if that 38th day is a Saturday or a Sunday and you're not open? Do you have to take that into consideration? How does that all sort of work and play out?
So this 38 days is the assumption you're allowed to make that the consumer has received it, right? And so even if it ends on a date like that, you can still tell them. Now, if a dispute comes in on the Monday following the Saturday in which you told them, you're probably going to honor that one because you've gotten it potentially during that time period. I have to think about that a little bit more. But these are sort of the rules that the Bureau has told us on how we can calculate it and disclose it to the consumer. The thing that I think potentially creates some risk is that we don't get our system right. We have to create the field. We have to create the programming for it. We got to make sure it's right. And of course, whether we provide the date or not, we always have to keep track of the inbound return mail and, and the bounce backs or whoever we're sending this thing. We have to make sure that we accommodate for the knowledge we receive that the consumer didn't actually get what we sent them.
John,
that
do
end-
you have?
Yeah, go ahead, Heath.
Yeah, I guess I would say, I think 38, 40 days is probably pretty safe, but I think the issue that we might see is, and I hate to say it, but we know these stupid issues come up in plaintiff's attorneys, but the plaintiff's attorney who sues you and says, well, you gave us this date, but you actually honored that after this date. So that was a false and misleading statement. We saw that whole line of cases with validating a dispute in writing versus over the phone. And I just see, I'm afraid we might see that issue creep up moving forward with validation notice as well, unfortunately.
Yeah, woe be unto the lawyer who brings that case. They're going to get immediately show cause by the court about what the standing is right there. Well, I was damaged because I had rights that I didn't think I should have.
Keith, I'm not sure if you saw, but we did get a question that says, what if your organization's policy is to honor the validation of debt requests and disputes past that date? Would that be considered a misrepresentation or deception?
In FDCPA attorney's mind, yes. Now, to John's point, can you defend it? Yes. Will you not get sued for that? You could still get sued for it. Hopefully, that's one, again, where someone else will get sued first. You can put your case on a stay pending that resolution, and that case gets kicked out.
So my prediction is that we're not ever going to see that claim for at least 5, 6, or 8 years, because there's going to be much lower hanging fruit for consumers and their lawyers to bring claims on, that if they have to go there, we're in good shape, right? We're in great shape.
Yeah, I think if the question is, should we leave it open if we take disputes anytime? No. Put the validation end date in there as required. And you can honor disputes at any time if you want to do that, but follow the rules on setting the itemization, setting the validation date.
Okay. Let's circle around to Brent, something you were talking about before, at least you mentioned before. So I wanted to make sure we talked about it, and that's time bar debt. Obviously, there are different requirements when you're collecting time bar debt that are part of the model validation notice, and maybe you can start walking us through there, and we can spend the rest of our time talking about that.
Yeah, and I think this is some of the lower hanging fruit that John was talking about. I think maybe the lowest hanging fruit that I do want to bring up is, we see a lot of letters where there's itemization that either leave a blank or put an NA. Don't do that. That's going to be, I think that's some of the lowest hanging fruit is stop doing that, because that is not allowed by the, if you want to keep the safe harbor for the model validation notice. But yeah, what I sort of expect to see is litigation about time bar debt disclosures. Now, if you're in a state, or if you're collecting in a municipality that requires specific language about time bar debt, then you can include that. This rule covers that. And in fact, if there's specific language you have to use, then you can put that disclosure on the front page, and that will help you comply with any local or state rules that require front page disclosure. The trickier thing is where you're just generally required. So in the Seventh Circuit, you're generally required to notify the consumer if the debt is time barred, but there's no specific language that's been dictated. So I would see that as something that you can put on the back page, because it is, what is the language that they use there? I don't have it handy right now, but it is required by applicable law. I think that's the language. So it is required by applicable law in the Seventh Circuit. And then you get also into the revival. And then where I've got concerns is, in places like the Fifth Circuit or the Sixth Circuit, or the 11th Circuit, which has had some, 11th Circuit said there's no standing for such a claim, at least in some circumstances. But, take a circuit like the Fifth Circuit, where you might have to give a time barred disclosure, but do you have to do a revival disclosure? If you do a revival disclosure, are you now going beyond what's required by applicable law? If someone says, well, the Fifth Circuit doesn't require that, only the Seventh Circuit requires that. So I think that's where we're going to see some litigation.
Brent, I share your same concern because when clients would come to us and say, look, should we be using out of statute debt disclosures? Generally speaking, I like the idea of a debt collector telling the consumer that the account is out of statute, even in jurisdictions that don't require it, right? Because there are a lot of the case law that has spawned in this area has resulted from consumers accusing debt collectors of making false representations by not disclosing the fact that the account was, and I'm concerned that Regulation F would not, well, I'm concerned that Regulation F would cause a debt collector to lose safe harbor if they include that disclosure in a jurisdiction that doesn't require it because of what you just described, saying, look, you're allowed to put optional disclosures that are required. But if it's not required and you want to do it anyway, you might do it at the risk of jeopardizing your safe harbor. That's the thing that I get concerned about.
Well, and John, adding further fuel to that fire, I think it's a very valid concern, because the CFPB in the preamble talked about thinking that even if not required by state law, if you're collecting on a time bar debt, a disclosure might be necessary to avoid a UDAP.
Yeah.
So, but going to, I think it was Brent before you, if you're going to make, if you are not required to make a disclosure, you will not be shown any quarter if the court doesn't agree that the disclosure wasn't misleading or was, look at the 1099-C disclosure litigation. Courts would say, this isn't actually required. There's no requirement you give a 1099-C disclosure in any law that is applicable here. You just have to send a 1099, right? 1099-C under the tax law, not disclose that you're going to do it. Since you chose to do it, even though you're trying to be helpful to the consumer, it's good for the consumer to know about this. You confused them. You didn't say it was in principle. You didn't tell them they could see an accountant. You told them they could see an accountant, but you didn't, specifically recommend the accountant they should use. I'm kidding. That one doesn't exist yet. But that same theory is going to play over and play over again here. Time bar debt is one of the areas that I actually, everybody please, don't fall out of your chairs or choke. I hope the CFPB does rework that portion because it is a mess. They suggest you need to give a disclosure everywhere in the preamble, which isn't law, but yet what does it mean? And you're going to hear some of your creditor clients asking you about that. They tell you you can include, to John's point, required state disclosures, but if it's not required, and they do say it's any case law, so that also gets even further confusing. So at least, Brent, you're talking about in the Seventh Circuit, there's judicially developed requirement, right? What about for other validation letter requirements? District court opinions, do we have to comply with all of those? I mean, it is disastrous. So I really hope this is one where they rework it. And if they want us to give the disclosure everywhere, just tell us to do it so that we don't have all these issues.
Well, I agree. I mean, that the CFPB, we were hoping the CFPB would fix this, and they had a proposal to fix it, but it was a disaster. And so I'm glad it didn't go into effect.
True.
I think it would be nice to get a fix to this and to get a safe harbor. I think it's very difficult to do. And so unfortunately, I think we're just going to continue to see litigation on it. But I've defended cases in, outside the Seventh Circuit successfully, saying that there is no requirement to either give a time bar disclosure, or there's no requirement if you have a time bar disclosure, but no revival disclosure, that there's no requirement for revival disclosure. And so now, but then a lot of companies that have defended those cases then started putting them in their letter, just an abundance of caution. So they didn't have to face any more of those cases. So now, I think the defense to that would be, well, 1692E in general, there's your applicable law. 1692E requires a time bar debt disclosure and maybe a revival disclosure if it's applicable. But now you've just said the opposite of what you argued in a case 18 months earlier.
The irony of a debt collector saying the statute requires a disclosure that we want to put in there, right?
That's what they're forcing. I agree, John. This is the nightmare one, and this is what I think the courts will sort it out. And we were supposed to be done with the courts sorting out validation notices, but unfortunately we're not.
Yeah, that was the great promise of the rule, that it's frustrating that it was anything but.
Well, unfortunately, we've run out of time. So we'll have to wrap things up. But Heath, Stephanie, John, Brent, thank you so much for sharing your time and your insights with everybody today. On behalf of everyone who watched and learned, thank you. We really appreciate it. I also want to thank TCN one last time for sponsoring this webinar. Please go to tcn.com to learn more about the company. When you log out today, you're going to get a screen should pop up with an opportunity to share your feedback about the event today, as well as any other ideas or panelists you'd like to see in an upcoming webinar. So please feel free to send me that. That's really helpful as we start planning more of these webinars going forward. So take a minute and fill that out. Until tomorrow, when we're back with Q&R, I hope everyone has a great day. We'll talk to you soon. Stay safe and stay well.